Hello everyone, today I'll be sharing another legal story with you. So what happened on 19 September 2025 is that the Supreme Court was dealing with the case of Kaveri Plastics versus Mehdoom Baba Behruddin Nural. Okay, so basically in this case, the Delhi High Court, they quashed a complaint that was filed under section 138 of NI Act, that is regarding the dishonor of cheque. Okay, so regarding the dishonor of cheque, a complaint was filed and that complaint was quashed by the Delhi High Court, and the ground of quashing was that the amount mentioned in the demand notice was of 2 crore, right, which is not same as per the check, as in check the amount, the check was issued for an amount of 1 crore. Okay, and the demand notice was served for 2 crores, right. This difference of amount, it renders the notice invalid. Okay, this is what the ground on which the Delhi High Court quashed the complaint. After this, Supreme Court, an appeal was filed in the Supreme Court against the decision of the Delhi High Court. Okay, after the appeal was heard by the Supreme Court in this case, they upheld the decision of the High Court. That is, they upheld the decision of Delhi High Court, and they said that the demand notice that is served under Proviso B of Section 138 of NI Act, it has to comply with the conditions of notice meticulously. Okay, so basically what is happening here is, see, once the holder of the check, he once presents the check to the bank, and the bank returns the check without any amount, that is, the check got dishonored. So in the case of dishonor of check, within 30 days from the day the bank returns the check, a demand notice has to be given to the person who has issued that check. Okay, and this is important and essential to constitute the offense under section 138, because it is an essential requirement to serve demand notice within 30 days of the dishonor of check. Okay, and Supreme Court said that the person who is serving the notice has to comply with the conditions of notice meticulously, that is, in great detail he has to comply all the requirements. Okay, Supreme Court said that even a typographical error, that is any typo error in the notice, would be fatal to the legality of that notice. Okay, so even the typographical errors are not allowed. Okay, failure to mention check amount or amount different from actual check amount in demand notice would stand invalid in eye of law. So basically, if you fail to mention the amount, the check amount in the demand notice, okay, or you mention an amount different from the amount for which the check was issued, okay, then in that case also the notice would remain invalid. Okay, the notice will remain invalid, as happened in this case of Kaveri Plastics, where the check was issued for 1 crores, okay, and the demand notice was of 2 crore rupees, which is different, so different from the amount of check. Okay, so in this case also the Supreme Court upheld the judgment of Delhi High Court, and they quashed the complaint because the demand notice was served for 2 crores, whereas the amount of check was only of 1 crore. Okay, a notice that is served under the Proviso B of Section 138, right. So this notice is being a provision in a penal statute, okay, and is a condition for the offense. So to constitute an offense under section 138, it is essential to serve this demand notice, and it is essential condition for the offense. Okay, it has to be precise, so the notice has to be precise, and the person who is serving the notice has to be precise while mentioning the amount of check which is dishonored. Okay, and even if the check details are mentioned in notice but the corresponding amount of check is not correctly mentioned, so you have correctly mentioned the details of the check, that is the check number, the date on which the check was issued, and all that you have mentioned. When it got dishonored, you have mentioned everything about the check details in the demand notice. Okay, but you have not correctly mentioned the check amount, okay, in the demand notice, that you failed to correctly mention the check amount. Okay, then in that case also the notice will remain invalid. Just because you have mentioned the other details of the check correctly in the demand notice, it would not make the notice valid, right? The focus here is on the amount of check, right? That has to be correctly mentioned in the demand notice. Okay. Supreme Court in this case referred the case of Suman Sethi versus Ajay K. Churiwal. So Supreme Court referred this case, and basically in the case of Suman Sethi, it was held that the demand must be for a check amount alone. So in a demand notice, the demand must be for a check amount alone, right? And if you are claiming additional claims like interest or cost of the suit, it has to be severed from the check amount. Okay, so basically the check amount that is mentioned in demand notice has to be clearly and separately mentioned from the other claims such as interest or cost. Okay, this is what was happened in the case of Suman Sethi, and it was referred in the case of Kaveri Plastic, right? And because since the amount mentioned in demand notice was different from the amount of check, right, the Delhi High Court, they quashed the complaint, and ultimately this decision was upheld and by the Supreme Court, right? So this is what happened in the case. So the learning is, whenever you are serving a demand notice, you have to correctly mention the amount of check in the demand notice, right? And if you are claiming some additional claim such as interest on that amount or the cost of the suit, any other thing, okay, they have to be mentioned separately from the demand amount, that is the check amount. Okay, thank you so much.